matter of Canada Goose UK Limited and another, and persons unknown.
My Lord, I appear for the appellants with Malone from Mr. Buckbit. There is no appearance by the respondents, but by invitation of the court, Ms. Wilkinson appears as advocate to the court.
I'm sorry about the slight delay in coming into court this morning.
Well, this is an appeal from the judgment of Mr. Justice Nicklin, wherein he refused summary judgment for final queer timid injunctive relief to restrain various acts committed at an ongoing protest at retail premises on Regent Street at the junction with Little Argyle Street. And he gave a number of reasons for rejecting summary judgment. The first was the absence of a valid service of the claim form on any defendant, which he described understandably as a fundamental problem. Secondly, the omission to name any individual defendants. And thirdly, his expressed concerns as to the manner in which the appellants had chosen to describe the defendants, which he said meant that he couldn't begin to say if any individual defendant, as so described, had any real prospect of defending the claim and couldn't know if they'd done anything wrong. And these were concerns he's expressed at the hearing itself, I understand, and these led to the submission of what we've called a substitute draft order on the 11th of February 2019, along with written submissions, which sought to meet or at least alleviate his concerns. But he said that the fundamental problem with that order remained that it included prohibitions on acts not unlawful per se. Notwithstanding those reasons for not granting summary judgment, the judge did grant permission to appeal. He recognised this is a difficult and developing area of law with few authorities, and thought this case demonstrated the limitations on the civil law in seeking to fashion, in effect, quasi-public order injunctions against the whole world. So, my Lord, it's in those circumstances that we come to this court and we bring this appeal. There are 4 grounds, although we only maintain 3. So far as ground 1, that concerns...
Let's just have a look at those to start with.
Well, the grounds are in the core bundle at page 17.
Yes.
So the first ground concerns service of the claim form, and we accept that we have to succeed on this, and that in the absence of valid service, the judge was fully entitled to refuse, indeed to entertain the application for summary judgment. And we need to succeed as against either the first defendant or the second defendant, because otherwise we have a fundamental problem of Rule 7.5 and service being required within 4 months of issue. And so if we don't get anywhere, then we're in deep trouble, as the judge himself recognised. My Lord, ground 2 concerns...
I may have misunderstood this. I didn't know that you were asking for summary judgment against the second defendant, because I thought that it was accepted that they had not committed any...
Absolutely, my Lord, that's absolutely right.
...unlawful conduct.
Absolutely correct. We indicated I think in the first written submissions, we wasn't sought against them. This is purely about service on them. Because, of course, if the claim form against the second defendant has been validly served, there remains a claim on foot, and therefore it would be open to my clients in the High Court to seek to add new parties, namely persons protesting, even if the first defendants here have not been validly served. The difficulty is that if there hasn't been service on either defendant, then the claim in effect has gone, and we'd have to start again.
Right. Well, in the court below, was it said by the second defendant that they had or had not been served?
They did not, well, they said nothing. In fact, there was no point addressed to my clients about the validity of service on the second defendant. And it was simply in the judgment.
Because the hearing was all about your claim against the first defendant.
My Lord, that's right.
So the point didn't arise.
Well, except that in the judgment, the judge does discuss the availability of summary judgment against the second defendant and says that they have a case to defend, although we had already withdrawn that claim for summary judgment against them.
Well, your grounds 1, 2 1, 1, 1, 2 and 1, 3 are all in relation to the first defendant.
My Lord, no, if one looks at grounds of appeal, the first ground of appeal is maintained against both respondents, whereas the remainder of the grounds concern only the first respondent.
Yes, I think my Lord's point is that 1, 2 and 3, the detail of 1, 2 and 3 are all about the first defendants, first respondents.
My Lord, in the skeleton argument we make clear that we seek to rely upon 2 and 3 in relation to the second defendant.
But the judge didn't deal with that point, you're saying?
The judge held there had been effective service against the second defendant, but not valid service.
Effective service, but not valid.
That's correct.
The second defendant.
That's correct.
Right.
So, well, that is ground 1, and I'll develop that in a few minutes. Ground 2 concerned the reformulated description of the first respondents and his holding that it was an impermissible one. And in particular, as I said, he noted that the prohibitions...
What was this? This was an application to amend the writ, was it?
It would in effect have been, my Lord, that's right.
Was there an application? And you can't just extract, I think, from this court a hypothetical academic point. It has to. What is it? Was there an application to amend?
There was no formal application to amend. The substituted draft order was placed before the judge and asked for him to consider it, and he did so, and he did not take any point in his judgment that there was no formal application to amend, and therefore he would not consider it.
It's all part of the problem that there's just one party, and so it's the judge. Judges don't take points about whether or not you amend.
Well, my Lord, I accept entirely.
There's no formal application to amend. The judge dealt with the documents he was sent after the hearing, which included the reformulation.
My Lord, that's right.
I mean, it's a slightly. The way it's formulated is, as I said, aimed at what looked like an academic point. He failed to. I mean, normally you would say the judge wrongly exercised his discretion in refusing to amend. That's how you'd normally put it. But you're not putting this. This isn't a discretion point the way you put it. It's a kind of an academic point.
Well, it's not, my Lord, in the sense that the judge said the fundamental problem was it described conduct that was not in itself unlawful, and we submit that is not a valid criticism. That the court can grant injunctive relief against persons in this category, which extends beyond prohibiting the commission of a tort where necessary.
No, I understand. Anyway, look, I'm just trying to understand what the ambit of the appeal is.
Lord, yes. I mean, I appreciate it's the way in which it was dealt with procedurally below is not ideal.
I mean, there is the order, I don't think, which is at tab 4, I don't think deals with this at all.
My Lord, it doesn't, no.
It wouldn't do. There was no application to amend. But never mind, we'll deal with that in due course. At the moment, I'm just trying to understand the ambit of the appeal. And then which is the other? You said three grounds.
Well, the ambit of ground 2 concerns, respectfully, Lord Justice Longmore's fourth requirement in INEOS as to the provisions for injunctive relief against persons unknown.
Yes, I understood that. I'm just trying to say that's ground 1 we dealt with, ground 2 we dealt with. Now you said there's one other ground.
Well, ground 3 concerned the judge's approach to summary judgment.
Yes.
And in essence, his approach appeared to be that he made a series of points in his judgment, the effect of which was that where one had brought a claim against persons unknown, being an emergency jurisdiction, the onus was then on the claimants to identify named defendants and pursue only them, and it couldn't maintain any claim against anyone else. And Also, within the course of his judgment, he made a number of points about the ambit of seeking relief against persons unknown generally. And our concern is that whatever happens in this court, as night follows day, there will be protests outside the appellant's premises, and therefore it will need to bring either new proceedings or these proceedings in the future to seek to prevent that. And it needs to understand, respectfully, what is the appropriate procedure and approach to follow.
Yes, the only reason I'm asking more about this is because 3 starts off in determining whether summary judgment should be granted. The judge erred in law in the approach he took.
Yes.
My understanding is you're no longer asking for summary judgment.
No,
So why doesn't this ground fall away?
because we're asking for remission back. And remission back and application of summary judgment on the correct principles.
Sorry, I don't follow that. Remission back.
Of our application for summary judgment.
I mean, well, the judge has refused it.
Yes,
So that's that, unless that's appealed.
well, that's right. But he rejected it on the grounds of service to start with.
Well, that's the first ground.
Yeah, that would do
But
it.
he rejected it on the facts.
Well, he did.
Much of the judgment is concerned with rejecting it on the facts. If you're not appealing that, it can't be remitted, can it?
But he's rejecting it on the basis of saying that it was incumbent on the claimants to identify the individual defendants.
Well, that's how you put it. I think
Yes.
there might be a debate about that.
Yes.
But just to try and ascertain where we're going, the judge has said no to summary judgment. It like the Master of the Rolls, it's unclear to me whether you challenge that and want us to say that the judge was wrong not to give just summary judgment.
Well, we do. We say he was wrong because he was approaching it on the incorrect principles. And because he's approaching it on the incorrect principles, he never went on to consider it on the correct principles and determine whether it should or should not be granted.
We will sort all that out. But at the moment, you're not asking for summary judgment against the second defendant.
No.
And if it hasn't been properly served on the first defendant, if that's the scenario,
Yes.
then I don't see at the moment how ground 3 can get you anywhere.
My lord, that's correct.
I mean, you can certainly say that strictly speaking that's true, but it would be very helpful for this court to give general guidance. We'd have to think about that, which I think is what I think effectively what you are saying.
Well, it is.
In the end, but of course that will then all be over time, and we'll have to consider how far we should go on that.
My lord, yes.
All right, but then anyway, thank you very much. At least we know where we are now.
Well, the fourth ground, we don't maintain the
I
fourth.
understand that because you wanted to be remitted anyway. So thank you very much. So in order to try to confine this appeal within appropriate limits, can I ask you please to accept that we've read the judgment and the skeleton arguments?
I'm grateful.
And it seems to us that there are a limited number of points of principle here under these grounds of appeal, and we really don't need to go over all the facts. We've got the facts
I'm grateful.
so far as we need them. And you can refer to any particular facts you want to, by way of emphasis, as you deal with the points of principle.
My lord, yes.
So I think what would suit us best, if this is acceptable to you, and obviously to Ms Wilkinson as well, is that we start straight with ground 1 and we go straight to what are the correct principles that you say the judge should have applied but failed to do so.
My lord, yes, I'm grateful. My lord, on ground 1, I'm therefore taking it that my lord have read the papers. I don't need to take you to any of the individual documents. I was going to take you to about half a dozen of them,
Well, why don't you do that?
I'm grateful.
Sure, we've got them.
but I'll keep it
Yes.
as limited as possible if I may. My lord, the first document is in the core bundle at page 137. That is the application for interim injunctive relief.
A moment, let's just get this. If you want to, while we're here, to save time later, you can draw our attention to anything particular you want to, but I mean, it's entirely up to you.
I'm grateful, my lord. And my lord sees that the application,
Core bundle.
core bundle 137, my lord.
Thank you very much.
And one sees that the application notice, paragraph 3, sought an order pursuant to 6.15.2 for alternative service of the claim form, discipline this application, a witness statement in support, and then 2 email addresses for Surge and PETA.
Yes.
And the draft order attached at page 141.
And we'll just note, so we note the defendant there, persons unknown who are protesting against the manufacture of clothing made or containing.
My lord, that's right. And my lord, we accept that was an overbroad formulation.
Accept that.
Yes. For the reasons the judge gave, includes people in Penzance, those who are doing absolutely nothing wrong. So well, that was what was sought in paragraph 3 of the application notice. The draft orders at page 140 and page 141 contained the draft undertaking to be given by the first claimant. And it's subpara 2, an undertaking to
Sorry,
effect.
so just
Sorry, my lord, 141.
To affect the email as provided for below.
My lord, yes. So that was clearly consistent with the application.
141, this is under, and upon the first claimant undertake to the court through counsel on behalf of all claimants, and then you rely on 2,
Yes,
including the reference there to the particulars of claim,
yes,
and the application notice and evidence in support.
yes. And then when one looks at the draft order at page 144, paragraph 3, what one notes about the draft order is there is no provision within the order for alternative service. Paragraph 3 provides the claimant shall serve this order by the following alternative method, namely by serving the same to those 2 email addresses.
So no provision for dispensing, was it?
No order for alternative service under 615, namely by service by email on these 2 organisations.
of
There was-
the claim.
Of the claim form, my lord, that's right. So there was a mismatch between the application notice and the draft undertaking and the order itself, and it is accepted that this was an error of the appellants.
So when you say there is no, I'm not sure I fully picked this up. There is an order here providing that it is to be served by this alternative method.
Lord, no, this is the draft order,
Yes.
and it includes an undertaking to serve it by the alternative method,
Yes.
but the draft order doesn't include provision for service of the claim form.
Oh, I see, the
But-
claim form.
yes.
Seems so sorry.
It's purely serving the order in paragraph
So
3.
the undertaking was in relation to the claim form, but there was no order for the service of the claim form.
My lord, that is the error, and that this was our draft, and there was an error within it.
Right. That's good enough, thank you.
My lord, may I then delve a couple of times the supplementary bundle, if I may, and it's to just highlight evidence that was before Mr. Justice Tier, and it's the supplementary bundle, page 3. Actually, the first witness statement of Mr. Hayton that was filed in support of the initial application for injunctive relief. In paragraph 12, he notes the defendants have their own websites, Facebook and Instagram pages on which they organise protests at the store. And in paragraph 13, he refers to a becoming aware of a planned protest, and he refers to a Facebook event page created by Surge in or around May 2017. And then over the page, in paragraph 17,
So you say created by Surge.
Surge.
Where's that?
That's paragraph 13, second line, my lord, right-hand side. And I'll take you to that page in a moment.
And then you were taking us over the page.
My lord, yes, paragraph 17, which recounts one of the early protests. One sees within the security log contains the following: low-level PETA attendance with approximately 20 subjects. And then at page 15 of the supplemental bundle is the web page that Mr. Hayton was referring to, created by Surge. And one notes at the foot of page 15 that Surge is described as a non-profit organisation. Surge is an animal rights organisation determined to create a world where compassion towards all non-human animals is the norm. And then midway down at the top, one sees the heading, Protest Against Canada Goose Coming to London. And there's a date provided, the 11th of November. And as Mr. Hayton has said in his witness statement, I'll just give you the paragraph 13, that page was first created in May when they learnt that the appellants were coming to London, but the date was updated as the opening date was set back and then crystallised. And then midway down the page under details, missing the first paragraph, it states, the protest will be held on November 11th, 11 a.m. to 8 p.m. Please read the pinned post. You'll see just above that, 456 went, 1.1k interested. And then under recent posts from Surge, thank you to everyone who attended today. You all did an amazing job at speaking out for animals and against the barbaric and disgraceful business. So that was the evidence before the judge in relation to both PETA and Surge. Can I return then to the core bundle, please, to Mr. Justice Tear's order, which is at page 174. So far as material for this ground of appeal, the order is in the same form. So one sees on page 175, the judge accepted the undertaking, including under 2, to effect email service as provided for below of the order, the claim form and particulars of claim and application notice. But when one came to the order itself, starting at page 177 but continuing 178, paragraph 3 of the order as made included the same error as has been in the draft, namely only providing for service of the order by the following alternative method, namely by email to contact Surge and PETA. Now, my lord, Mr. Justice Nicklin, when he came to consider the matter, didn't have before him Mr. Justice Tear's approved judgment. He had a note of judgment which was silent on this issue, except this issue was not addressed at the hearing. But I should take my lords to that judgment because there's a paragraph within it that could be said to militate against part of our argument. Therefore, I must do that if I may. And so that's at core bundle, page 201. And it's within paragraphs 6 onwards of the judge's judgment, where he is considering section 12 of the Human Rights Act and the limitations on the court when granting relief that's going to impact upon convention rights. And as my Lord's note in paragraph 6, he records that subsection 2 provides that the court has to be satisfied that after taking all practical steps to notify the respondent, or that there are compelling reasons why the respondent should not be so notified. And then he sets out the reasons for the appellants applying, i.e. fear of notice of further protest and inability to serve the claim. And then within paragraph 9, he concludes there are compelling reasons. But then the third line, right-hand side, there is a website with which some of the protesters may or may not be connected, but no individuals are known who can be served. It therefore appears to me that necessary compelling reasons are established. And so I draw my Lord's attention to this because, of course, it could be said from this that the judge, having noted the website, could not be satisfied that some or all the protesters were connected with them. And I have to accept that. So, my Lord, that was the judgment of Mr. Justice Tier.
Sorry, can I just understand that judgment, which was 29th November
Yes.
2017, wasn't before Mr. Justice Nicklin?
No, he had before him a
How was
solicitor's...
that?
I have to take instructions, my Lord. He had before him
It
a
was
noted
over a
judgment.
year between the two judgments.
Yes. May I take some instructions to find out?
Well, don't worry about it now. It just seems a bit odd.
Anyway, the point about paragraph 9 of the judgment, which you're rightly taking our attention to, is that if one was looking at an alternative method of service,
Yeah.
this alternative method, Mr. Justice Tier recognised, might not be appropriate for informing everybody.
My Lord, that's right. Well, following on
I
from...
just understand that. Well, why would that be so?
Well,
Why did you suggest service by email
my Lord,
to surge.com? Because that wouldn't mean that it became public.
no, but the rationale for doing it was that Surge had been the organisers of the protest, as demonstrated by the website. And
Why didn't you couple it with an order that the website owner places it on the website and their Facebook page?
my Lord, that is the...
Because, I mean, the most obvious thing for them to do would be to ignore it.
Well, my Lord, the expectation was that that was the best means of bringing it to their attention. And it's quite right that PETA, who were served in the same way, then did apply to be joined. But I accept my Lord's point. Well, what then happened is that the appellant wrongly believed that the alternative order for service had been made and therefore served the claim form, particular claim, etc., by email to both PETA and Surge. And as evidence demonstrates, PETA accessed the documents, and it's right that there's no evidence that Surge did open the documents, but equally there was no bounce back from them. But I accept that they were not open.
So PETA accessed the documents, but
Surge did not. PETA then applied to be joined as a defendant, and that matter came in front of His Honour Judge Maloney, Queen's Counsel, on the 13th of December, which had been the return date for the injunction. And his order is in the supplemental bundle at page 293.
that's the 15th of December, is it?
Well, it was actually made on the 13th of December.
Very odd.
Yes, because if one looks at page 294,
Dated the 14th, the 15th.
yes, because if one looks at page 294, it requires action by the 13th of December by PETA. What he did is he heard it on the return day the 13th, made this order, and then adjourned over the return day until the 15th. And one notes from
You
paragraph...
adjourned it over, what?
Return date of the injunction. Because it's not just Tier had placed return date the 13th of December. PETA applied to be joined on the 12th of December.
The actual hearing, what you're saying is the hearing was on the 13th.
My lord, yes.
You're actually saying he made the order on the 13th as well.
He did, yes.
Are you saying it was wrongly dated the 15th?
It is, yes.
I see, thank you.
And one notes that PETA were in attendance by counsel, and by paragraph 1, PETA were joined as a defendant in their own right and also in a representative capacity. Paragraph 2 adjourned over the return date for 2 days. One notes from paragraph 4 that by no later than 2 p.m. that day, the claimants were to provide PETA with copies of the skeleton argument before Mr. Justice Tier and the solicitor's note of that hearing in the interim. And there was no provision within this for service of the claimed form, or particular claim, etc. Unsurprisingly so, because those had been provided to PETA by email some days previously, and they clearly accessed them as the basis for then applying to be joined. And then I think, my lord, on the 15th of December, and I don't need to take my lord to it, but His Honour Judge Maloney then reconsidered the interim relief. He granted it in certain terms, and he also stayed all further procedural directions until a long stop date of the 1st of December 2018.
Which date?
1st of December 2018, in effect putting the claimant to his election either to apply for summary judgment or further directions, or the action would stand dismissed. And just to complete the chronology, if I may, and I'll go to my submissions. I appreciate this is a procedural ground. A year later, when the appellants did apply for summary judgment, Master Eastman ordered service of that.
Sorry, where do I find in this order that last statement of yours? It stood over until the 1st of December 2018.
The order's at page 186.
Right, this is another one.
Yeah, this is within the core bundle, not the supplemental bundle.
So we're going back now.
Back
so
to court,
he does
yes.
this order on the 13th. Now you're going to show us the order of the 15th. Right.
An injunction and the order on the 15th starts at page 182. And then on page...
How does this differ from the previous one?
There were some differences from the order of Mr. Justice Tier. The principal one being that Judge Maloney blended together the two outer exclusion zones into one. But in terms of procedure, on page 187, or rather 186, paragraph 7, having made the order, he then provided all further procedural directions in the claim shall be stayed, save for purposes there. And then in paragraph 8, set out a mechanism by which the claimants were to progress the claim, either by applying for case management conference or if served by a summary judgment, and in any event by no later than the 1st of December 2018. And if none of that was done by that date, the claim would stand dismissed and the injunction discharged. My Lord, then just completing the chronology, if I may. When the appellants did apply for summary judgment, they obtained an order from Master Eastman on the 30th of November 2018.
Can we just see the application for summary judgment?
My Lord, yes. That is within the core bundle. sorry, it's the supplemental bundle, my lord. Page 295.
That is only against D1.
Oh, Lord, that's right. Well, it does say and others.
Otherwise, is that supposed to be and that? Is that
Yes.
supposed to be?
And it is right to say the application for summary judgment was initially made against both defendants.
Because it says and others.
And that was maintained, the application was maintained against both defendants at the hearing in front of Miss Justice Nicklin, but then in written submissions filed in February 19 made clear it was no longer pursued against the second defendant.
In written submissions in February 2018.
19.
After the hearing at the end of January.
My lord, that's correct. The judge has indicated that he expressly gave the appellants permission to file additional submissions. And in fact, there were 4 sets of submissions between then and judgment. Three of them elicited by the judge's additional comments and requests for assistance.
That was supported by one witness statement.
Well, it was, yes.
That was the only evidence, was it?
Right. And then there was an order of Master Eastman on page 306 of the 30th of November 2018. Upon reading a witness statement of my solicitor, Mr. Hayes.
Sorry, where is that?
So page 306 is the order.
Thank you.
And there Master Eastman provided for service of the application and evidence and support by email to Surge and PETA.
Right.
And then finally to explain what material or what the judge is being asked to do, if I could take my lords to the supplemental bundle, page 344.
Well, just pausing there, the application for summary judgment seeks an order in the form of the draft order attached.
Yes.
That's at page 298.
Yes.
So this is what the judge is being asked to make.
Yes, absolutely.
So we just want to look at that later very briefly.
So the first point to note, of course, my lord, is this is the formulation of the defendants, which is the broad formulation.
Yes.
First defendant.
Yes.
And then what the appellants sought to do when they made the application was to reinstate the 2 outer exclusion zones that His Honour Judge Tier had originally ordered. Sorry, Mr. Justice Tier had ordered. His Honour Judge Maloney had blended, and they took the view, the appellants took the view that that had given rise to unacceptable obstruction, therefore sought to go back to the earlier formulation. Someone sees on page 300 amendments demonstrating what those 2 zones were to be. And then the differences from the order that was in place are indicated on page 301 and 2.
Right, so this is, can we just see what this is? So this is exactly what is supposed to cover: assaulting, molesting, or threatening. And what these amendments in blue and red, when do they date from?
Well, these were, sorry, my lord, when did they?
This order is attached.
Yes,
What is it? It's showing the amendments to the existing interim order.
my lord, that's correct.
Why are some in red and one in some in blue?
I think the deletions are in red and the additions are in blue.
Ah, okay. Thank you. And just, if we can, just so that we've got the force of this, the judge felt that some of these matters, and I think this is accepted by you, would not necessarily be unlawful.
My
So
lord,
I suppose that would come into matters such as, I don't know, entering the store perhaps.
I think entering the store would be a trespass.
It might or might not be, depends.
But I think that was a point the judge made, and when one looks at the substitute order, I think that was amended. So yes, that's a fair point.
So what is the fact?
That entering the store may or may not be.
Might or might not be.
Absolutely, yes.
And I suppose photographing people, that's not necessarily unlawful, is it?
My lord, it could amount to harassment under the 1997 Act,
Yes.
but we accept in this court that there are issues for relief under that Act.
But photographing may or may not,
Yes.
intentionally photographing other people isn't of itself
No.
unlawful.
No.
It may amount to harassment in certain circumstances.
My lord, that's right.
That's the point.
And the same is true of demonstrating,
Well, absolutely, that's right.
and that's a lawful activity.
Absolutely. And I think that the judge's principal concerns, I think he had a number, I accept, was the restriction, the prohibition on demonstrating in the inner exclusion zone, i.e. a complete blanket ban, and then the limitations on numbers in the outer exclusion zones. Again, the point he made is, well, demonstrating is perfectly lawful, it's an important right enshrined in the convention. How am I to know if 12 people or 14 or 16 or 20 crosses the line to what is and is not unlawful obstruction of the highway as opposed to lawful demonstration?
One person standing with a placard at 2 o'clock in the morning in the inner exclusion zone is hardly likely to be unlawful, is it?
Would not.
And if it's a loud hailer,
My lord, the basis for this is that,
might or might not be.
well, it is, and the evidence that was before the judge was that loud hailers were being used constantly, on sort of siren mode, and not for the purposes of imparting a message, and this was causing a great deal of nuisance and inconvenience to everyone. And so what was sought to be done here was just, rather than say, well, decibel levels or whatever, was to try and fashion a form of relief that balances rights as to what is a nuisance and what isn't a nuisance. I accept it's imperfect, but
I'm not, at the moment, I'm not expressing any view about legality or otherwise. I take your points. I just wanted in advance,
My
given
lord,
the
yes.
next stage,
Yeah, that's right,
to
sorry,
see which parts of these might be
my lord, yes.
lawful, depending upon the circumstances.
My lord, yes.
So I think we've identified demonstrating, entering the store, photographing,
Yes.
and loud hailer. Anything else here that might be, the judge thought might be potentially lawful?
My lord,
Well, those are the main ones.
we think they're the main points, yeah.
Very well, thank you. Yes, we've seen that.
And my lord, so that was and again, the obvious point to make up 298 is that it's the definition of the first defendants that gave the judge extreme concern.
No, of course.
My Lord, there was then an order of Master Eastman on the 30th of November. That is the day that the application notice was issued. We have it at 3:06. And Master Eastman directed that service of the application and the evidence and support be my email to Surge and PETA.
Very curious, this, isn't it? I mean, as my lord has pointed out, I mean, I would have thought it was quite elementary that just giving email to somebody isn't necessarily going to bring to the attention of all the people who supported Surge these proceedings. I mean, I thought it was quite a straightforward point, really. But there we are.
And my Lord, as a result of that, there was a further witness statement filed by my instructing solicitor, confirming that service was effected in accordance with that order. Against, there's no evidence that the Surge documents were accessed. I'll say that. Well, there was then the hearing before Mr. Justice Tier on the 29th of January.
Nicklin.
Sorry, yes. And then the judge requested further submissions.
It was one day hearing, was it?
It was, yes. And he requested further submissions.
Who was present there?
Present was solely Mr. Buckbit, counsel and solicitor and client. There was no attendance by any respondent. PETA had responded to the application, but stated that they did not intend to appear. I ought to take my lord just to that confirmation. Which I think is at page 290 of the supplemental bundle. It's a witness statement of Eliza Allen on the 15th of January. Noting that whilst under agreed on the facts, we will not formally oppose the application. 2. It will matter for Canada Goose to persuade the judge that the proposed variations meet the legal test and show the court they follow the correct procedure for making the application. One point I make is that there's no assertion there by PETA, you haven't served us with the claim form, how can you proceed? My Lord, there was then the hearing before Mr. Justice Nicklin on the 29th of January, and it is correct that he raised a large number of concerns.
Sorry, there's another hearing, you say?
No, there wasn't.
Oh, sorry, not 29th of January. Yes,
Yes.
29th of January.
He gave permission for the appellants to file additional submissions. And just for my lord's note at the moment, additional submissions were filed on the 11th of February 2019, and we have that at page 307.
Which supplementary model?
The supplementary bundle, yes. In fact, whilst we're in the documents, it's probably as well to go with these now rather than coming back to them. Because that,
36 pages
my lord, yes.
of further submissions
My lord, yes.
after a one-day hearing in
Yes,
a case where only one side were represented.
My lord,
I suspect it was one of these hearings where counsel found that he had an opponent, as it were, sitting on the bench. There were a lot of points being raised, is that right?
I think there were a number of points raised, and as my lords can see from Justice Dixon's judgment, it's an incredibly thorough and detailed judgment on a range of difficult issues. And it's fair to say the judge did require assistance with a large number of points and gave permission for all that.
Yes.
And so we have at page 307 the written response on the 11th of February. And if I can just take you to paragraphs. If one sees the from paragraph 5 onwards, the court was concerned with the manner of describing the first defendants. And so one has a analysis here of the various authorities Paragraph 8, the Bloomsbury case, 9 Hampshire Waste, 11 Cameron Hussain in the Court of Appeal as it was. And then the analysis of Mr. Justice Marcus Smith in Bastin, paragraph 14. And it was referring to the various use of categorisation of defendants. Then at paragraph 29 on page 316, the appellant said, insofar as the court remains troubled by the conceptual issues raised as regards the present description of first defendants, it submitted the alternative. The court's concerns would be addressed the following if the heading description was amended to read. And a proposed different version was placed here. And this sought to limit the original description by virtue of presence at or in the vicinity of Regent Street. Secondly, the act of protesting against the manufacture or supply of sale of clothing. And thirdly, involvement in any of the acts prohibited by the terms of the order.
Sorry, can you just give me the page reference again?
316, my lord,
316,
paragraph 29.
Thank you. Yes,
And what was said there is such a description removes the anomaly caused by the pleaded definition that innocent protesters are immediately parties to the claim and caught by an injunction which would not be made against them if they had been named defendants. And in addition to that, page 341, paragraph 121, the substitute form of order is referred to, and it's stated, insofar as the court remains concerned as to the description of the defendants and or granting such relief in respect of defendants as described, the claimants will seek an order in an alternative format and permission, so far as required, to amend the description. A draft form of order is provided with these submissions. The court will see that it makes clear that it is only those elements of the order that are themselves likely to cause harassment that may give rise to criminal sanction under the 1997 Act. And that is the substitute draft order, which is in the core bundle, which I'll take my lords to underground too, if I may, unless you'd like to go there now.
No, back here then.
I'm grateful. Well, that is in the core bundle at page 191. My lord, it doesn't show the differences between the original order. I have, for my own purposes, done a coloured version, but would that be assistance if I can get that copied at...
Yes, that would be helpful.
I'll get that done over the short adjournment.
Thank you very much.
And so one sees from the heading that the description of the first offenders has been altered to limit it in the three ways I've indicated. Over the page, on page 192, there is a limitation of the first paragraph. There is a limitation of those paragraphs of the order said to have been made under the Protection from Harassment Act to some 5 paragraphs. Whereas under the order granted by His Honour Judge Maloney QC, it had provided that all paragraphs had been made under that act. There was an addition in the second paragraph about taking notice that any person who considers they are affected by this order may apply to the court to vary or discharge it, as provided for below. That was new. And I'm only taking my lord to these material differences here, but I'll hand that in. And then when one comes to the definition of the prohibited acts, one notes from paragraph 5 that entering the store has been altered to entering the store without consent and or remaining in the store when asked to leave.
Yes, that's obviously changed.
the outer exclusion zone had returned to being one zone only, with 12 people within it. And it had also been amended to make clear that the breach would be committed if there were already 12 people there and a 13th person came. Whereas under the previous order made, it was unclear as to who would be liable if there were 13 people there. And then I think the provisions at allowed hailers was split into two in paragraphs 15 and 16, but no substantive difference. So well, that was the substitute draft order provided to the judge with these submissions, and he was asked to consider this in the alternative. And in fact, in his judgment, he does do so. We'll come to that in due course. The final matter is the judge also asked for submissions on service on the first defendants. And at supplementary bundle, page 344, are further submissions by the appellants. And one notes at the foot of the page there is recorded the email from the judge's clerk, assumed to be in the light of the Supreme Court decision Cameron and Little Victoria. Have the first defendants, or any of them, been validly served with the claim form? If so, what is the base of service that is relied upon? And the submissions then deal with that issue, and they recognise in paragraph 8 on page 346 that the order as made, i.e. paragraph 3 of Mr Justice Tier's order, does not deal with alternative service and seek relief under the slip rule in 40.12. And in the alternative at paragraph 14 on page 347, it's stated, insofar as it's considered inappropriate to amend the November order, there is an extant application for service by an alternative method, and the claimants would respectfully invite the court to make such order, it being open to the court retrospectively to permit steps already taken to constitute service under CPR 6.15.2. And then on page 348, under paragraph 19, in the further alternative, a request to dispense with service under 6.16. Well, that's the material. The judge held there had not been valid service on any defendant, and he declined to exercise his power under the slip rule, and he gave 3 reasons. And shall I turn these up, my lord? It's the core bundle, page 120, paragraph 141 of the judge's judgment.
Core bundle page.
Page 120, it's paragraph 141 of the judge's judgment. And he gave 3 reasons here in paragraph 141. The first one being that the court will only grant an order for alternative service where satisfied the proposed method can reasonably be expected to bring proceedings to the attention of the defendant. Service on the email address content at Surge could not reasonably be expected to bring the proceedings to the attention of anyone other than the person who accessed that email address. No reasonable expectation this method could bring the proceedings to the attention of a wide class. The second reason is that 5 lines down, the judge could not be satisfied on the available evidence that this was simply a slip. and over the page, Roman 3, any application to amend could only fairly be considered and determine the benefit of a transcript of the hearing and in the light of CPR 40 BDP arguable to be considered by Mr. Justice Teal. And my Lord, in terms of our submissions on the judge being wrong in refusing to exercise the power under the slip rule, I don't take my laws to the rule. Of course, the court has power at any time to correct an accidental slip or omission. I accept that does not permit the court to have second or additional thoughts.
Yes, my recollection is that you can't use the slip rule in order to change a judgment or an order to something which you didn't think about, but if you had thought about it,
That's right.
you would have decided a particular way. So you have to show that actually the intention was always there
My Lord, that's
to
right.
do whatever it is
My
you
Lord, that's
want
right.
to correct by slip.
Absolutely. It has to be to reflect the intention of the court.
Well, we've got a problem there. I'm having a fundamental problem because there was placed before Mr. Justice Teal a draft order that he was asked to make, and if his intention was simply to make the draft order, that's what he did.
My Lord, what we say is that the judge clearly had before him the application notice, and he had the draft order, and he accepted counsel's undertaking, and that undertaking was to serve the claim form, the particulars of the claim, and the other documents by those two email addresses. And we say that is only consistent with his intention that this was to be by way of alternative service under CPR 615. Because otherwise, he would not have accepted the undertaking.
But when you say he accepted the undertaking, you rely on the order,
My Lord, yes.
but we don't know actually what happened in court, do we?
Oh, my Lord. Well,
I mean, you could.
it's not
if
suggested
you're
that...
relying on if you're relying on the undertaking, on the order to demonstrate the undertaking, you equally have to rely on the order to demonstrate the order he made. We don't know whether counsel actually orally offered that undertaking.
Oh, my Lord. No, we don't have any evidence.
We've got no transcript.
No, we don't.
I don't know why not.
Well, I don't believe that this issue was dealt with orally at all.
I.e. the undertaking was not offered orally.
I don't believe the issue of alternative service was dealt with orally at all. The judge clearly had the order,
Right.
and in his judgment that we have seen, he did refer in his judgment to paragraphs in the order, in the other part, including this, paragraphs 4 and 6, but he didn't refer to this, and we can't say that he was
The
addressing it.
short point here is, can you use the slip rule where the judge makes an order which he's asked to make, and within the order it's apparent that the method of service is intended to be in a particular way, but the actual form of the order doesn't state that. That's the proposition.
Yes.
That you have to say, well, I mean, that is a case, isn't it, where it's a case of saying, well, if the judge had brought his mind to bear upon the point, or indeed anybody else had for that matter, they would have realised it. I mean, isn't that a classic instance of what I was describing before?
Well, no, I'd submit this. Well, I mean, our submission has to be that based upon acceptance of the undertaking, which he clearly accepted,
Yes.
that is consistent only with permitting alternative service.
Yes.
But the order is incorrect, and it's our error, and we accept that.
I mean, the problem is we don't know where the slip is. Is it in the undertaking or is it in the term of the order?
Well, my Lord, one does know also the application notice itself.
Yes, and the affidavit, the witness statement.
Yes, and clearly this was a case, by virtue of the definition of the defendants, there had to be alternative service of the claim for, in one way or another.
All right.
Is there any, I'm sure there are lots of statements in the White Book about this. Is there any one particular case which can help us on this issue?
My Lord, there's the only, I think we've referred to one case, and that's Lord Justice Alderson, Bristol, Myers and Squibb, but that just makes the point that can only be to give effect to the intention of the court.
Shall we just have a look at the name?
My lord, yes, that's the authorities bundle, tab 9. Oh,
Oh, I see. Right.
yes, we also have the slip rule from the white book in the authorities bundle. If you prefer to go to that.
Yes.
The slip rule itself is at tab 7.
Tab 7.
My lord, yes. The
Page.
authorities bundle. It's the first page, rule 40.12. Oh, sorry, it's not. It's page 1301. It's a few pages in. Sorry.
Thank you.
My lord, it notes that the so-called slip rule is one of the most widely known and misunderstood rules. Yeah, and it refers to Bristol-Myers Squibb, which we have in the bundle. And the court there reviewed the CPR, pre-CPR authorities, and explained they established the rule cannot enable a court to have a second or additional thoughts, as once the order is drawn up, any mistake must be corrected by an appellate court. However, it's possible under the rule to amend an order to give effect to the intention of the court, citing Lord Justice's orders. Essentially, the rule exists to do more than correct typographical errors, such as where the order says claimant when it should say defendant. Or
This
is it
isn't a typographical.
My lord, it's not, no.
Here we are, then we've got this, it's the paragraph over the page on the question of extent to which the slip rule may be used to put right a defect in an order due to an accident omission of counsel to ask for or the court to provide for something.
Although it is accepted by Lord Justice Aldous in Bristol-Myers that one can, of course, exercise the power under Rule 4012, where the slip is that of the party or counsel or solicitor for them. My Lord, in our scope and argument, we submit that the judge was wrong in each of the three reasons he gave, in very brief form, if I may. So far as the first reason, that is that email to Serge could reasonably be expected to bring proceedings to the attention of the wider class of person. What we submit is that that was a misdirection in the sense that what the judge was being asked to do there was to put himself in the shoes of Mr. Justice Tier and consider his intention, and not for himself to think, well, I don't believe it could come to the attention of the parties and therefore I'm not going to exercise the power. In addition, he didn't refer to the fact that service was also provided to be on PETA, and that did in fact come to PETA's attention, so much so that they then applied to be joined to the proceedings as a defendant.
Sorry, what's the point you're making about PETA?
That well, the service was provided for two means on the
Yes.
defendants,
One on to Serge,
and one to PETA.
yes,
And his point was, well, for Serge, you don't know who's going to see it.
no,
Now, he doesn't deal there with the fact the service was also by PETA, and it was accessed by PETA. And
That's different. Because that PETA is an entity that's the defendant.
No, PETA wasn't at this stage a defendant. The PETA applied to be joined as a defendant, having been served by email, along with Serge.
But it was as my lord says, it was an entity. So and it got an email.
Yes, but so too
and the
was
judge
Serge.
found that was effective service
But so too was
On PETA.
on PETA. That's
But we're concerned with bringing the notice to the attention of all those people who might be protesting in the future.
Yes.
But it's obvious, we've just discussed that before, isn't it? it's obvious that if you simply send an email to one entity without specifying how they are to disseminate it amongst all the people who might be members of it or what otherwise, that doesn't get you anywhere.
The only point I can make is that it was an email to two entities, one of whom did act, but I take my lord.
Surge is not an entity.
Well,
It's just we don't quite know what it is.
no, that's true, my lord. We don't know if it has legal personality. That's right.
We don't really know what it is.
My lord, I accept that. My lord, the second point I've already dealt with, that is whether the court can discern properly the intention of Mr. Justice Tier.
Your point on 141(1) is that it's not really relevant. The point is, what did Mr. Justice Tier intend to order?
Oh, no, that's right. Yes. Point two is the judge couldn't be satisfied on the evidence there was simply a slip, and didn't accept that accept the undertaking. I've already made my submissions on that. And then the third point is it should go back, ideally, go back to Mr. Justice Tier, and should have the benefit of the transcript. But we say that's not.
I don't think that. But correct if I'm wrong. I don't think that is mandatory.
No,
It's obviously desirable,
yes,
but it's not mandatory.
no,
You can certainly say that.
yes. So we say well, if the judge was wrong in any of the reasons he gave, it's a matter of this court to for itself to determine whether there was a slip. I think we've already had. I've already made my submissions, and we've had that discussion as to what the court considers them. My lord, the second way of putting it is that the judge ought to have exercised his power under Rule 615(2) to direct that means already undertaken was good service. Now, the judge did not actually deal with this in his judgment. After paragraph 141, where he deals with slip, he then states 142, Mr. Buckpitt's fallback position was 6.16. Although, as I've indicated to my lordships, in the further written submissions, 615(2) had also been placed after the slip rule.
But you might say that the judge in effect dealt with it in 144(1).
Yeah.
And I think that's how we say in our skeleton argument. He didn't deal with it in terms.
If you decided that sending the email wouldn't be an effective alternative service, the reasons he's given there, then obviously you don't have to deal with the situation that you should have said it's effective service anyway. And if you're right in relation to the 141, one point, this doesn't arise.
Yeah, that's right.
So at the moment, it doesn't seem to me you get anywhere on that particular point.
Well,
Either you don't need it, or if you do need it, it's already been decided.
Yeah, and we have our written submissions anyway. I don't see to take the court's time in dealing with that. And the further alternative is the same point. That's 616. I mean, I can conceive that if we don't get anywhere on the 615
It's the same point, really, isn't
Yes,
it?
it
It's
is.
just put in different ways.
Yeah, it is.
Basically.
And the only point we make here is that this is not a normal case where you can't say that people know about the proceedings, because here the individuals described as defendants at the store, more than 300 were served with the terms of the order. That order, the injunction, so they knew of the proceedings. They knew of the identity of the claimant's solicitor. They knew from the order they could apply to various outside if they want. So they were aware of the proceedings, even if they did not have a copy of the claim form and the particulars of claim.
That's quite a dangerous route, isn't it? If you start saying, well, people are aware of proceedings and therefore we can dispense with service.
Well, it's only in this very particular case where one had an injunction order issued by this court, making clear there were proceedings, who they were against, what it forbade, gave them permission to apply to vary or set aside.
Isn't there another difficulty with all of these points about the slip rule, or should have exercised powers under 616? That would have all been by reference to the first defendants as originally described. And it's accepted that that's not the right defendants.
My lord, that's right.
So it would be a bit like suing a company, X Limited, and then the point arising that actually the right defendant was X UK Limited, and therefore a completely different legal entity. And all of these arise in relation to the wrong entity in any event.
Well, my lord, I accept that as things went, that's correct. But this was simply to try and demonstrate there had been valid service of the claim form when issued, i.e. within the 4 months. The proposed alternative formulation of the defendants, in effect, was a narrower class. It didn't apply to anyone at that time. And so I accept that had we sought to amend to include a wider class of defendant, it may be said, well, whatever service you did in November 17 can't be good against them. Here, where we're seeking to amend to narrow the class only to those present undertaking the acts, a similar concern can't be raised.
Okay, that actually, sorry.
So I think that you're slightly talking cross
That's right.
purposes. I think because you suddenly sort of threw into the mix a reference to 300 people having actually been served
With the
as
injunction.
though the injunction, as though that was a reason why service should be dispensed with. But my lord's point was, with all these people who've been served with it, on if the judge was correct, were served with it, but it was the wrong defendant. In other words, what they'd been served with was, as at that stage, a defective writ. You can't rely. In other words, I think what the point's been made is you can't rely upon service. In order to boost your case for saying the judge should, in his discretion, have waived service, you can't rely upon the fact that a whole series of people, I think you said 300, had been served, but with a defective writ.
Well, my lord, respectively, we say we can, because what one is determining is, has there been valid service of the claim form? There's a completely different issue, that if one then seeks to amend the definition of defendant to something else, does the court require the writ to be reserved on a class of person?
If it's the wrong defendant, usually, yes, you do require the claim form to be reserved.
I would accept ordinarily you do, but the oddity of this case and of these cases is that you're seeking to amend it to focus only on a class of person who are, in fact, not in existence at the moment.
Right. Anyway, the 300 people were served. What exactly were they given by way of service?
They were given the injunction made by Mr. Justice Tier.
And that's all.
And prior to that, the injunction of His Honour Judge Maloney. That's correct.
Other way around.
Sorry, yes.
Injunction of Tier and then Maloney.
That's right, yes.
But not the claim form or
Not
the
the-
particulars
no.
or the response.
No. Accept all of that, my lord. I have to accept all of that, yes.
But I'm just a little bit puzzled by something you said. The 300 people, supposing you served the claim form, I mean, are you restricting this claim to those 300 people?
No, we're not.
No, I don't think so. So, when it refers to people who are protesting or so on, that's the present tense.
Yes.
And does that speak, as at what time does that speak?
The claim is formulated.
So, what do you mean, so?
As the claim is issued. The defendant as issued. Yes, it,
Well, no. So, you mean anyone who at the time of issue was demonstrating?
no, I think it was intended to apply to anyone who, during the course of the proceedings,
Up to and including judgment,
absolutely, it would,
but not beyond.
well, that would then come into the terms of the court's power to grant
No,
injunctive.
but I'm asking
Yes,
you what this is intended to.
my lord, it was intended to. I think it was intended to deal with anyone protesting against Canada Goose at the store at any time.
You did have said, if there's an order against those who are protesting, I mean, on the face of it, that would look to see as if it was the time of judgment. So what you really meant was anyone who has in the past or does in the future protest.
That's right. Yes.
That's actually what it meant.
Yes.
I just wanted to be clear about that.
So can I just press on the 300 worthy people? you've got 300 people who have been served, leaving aside the point about how they're described,
Yes.
leaving that to one side. You've served them they've been served with the injunction,
Yes.
but not the particulars of claim or the response pack.
That's correct.
But don't you accept that for proper service, you would have to serve both?
My lord, absolutely. I accept that for proper service, to make someone a claimant, they have to be served with a claim form, or there needs to be a method of alternative service which binds them.
So,
I can only put it on the grounds that I can only put it on the grounds that where the court is considering the exercise of its power to dispense with service under 616, where a large number of the defendants, and I can't put it any more than that, are aware of the proceedings because they have been served with the court's order, and from that they know about the proceedings, they know they can apply to vary or set aside, and they know the claimant's solicitors and can get hold of the documents. In those narrow circumstances, the court can dispense under 616. But that's the only way I can put it.
thank you very much. Yes, I see that. Thank you very much.
When I opened the appeal, I said that the judge described service as a fundamental problem. I don't dissent from
Because
that.
the effect of the suggestion that you don't you waive service means that basically there's never any order, even for alternative service, of the statement of claim, of the particulars of claim. You're waiving something that's never ever been served on them, and which I think you accept, had the order been properly drawn in the first place, would have been served by an alternative service.
But it would have been, yeah, it would have been served on.
So I mean, so
on
basically, the effect of
Yes.
of waiving service means that you're putting them in an even worse position than if the order had been in the form that you say it should have been in.
But part of the power to dispense is recognising what steps we did take to try and bring it to attention, and that includes the.
I think you probably
You
can't.
may have answered this point. I'm sorry if I missed it, but this in your ground 1, 3,
Yeah.
which I think we're all at the moment, the waiving service, that would apply only to the 300 people.
Oh my lord, I have to put it.
Is that how you put it?
Well, I have to put it. That doesn't really help me.
You have to put it wide.
I do,
You have to
yes.
say it's everybody.
I do. I have to. Yes.
So in other words, the fact that the injunction order was served on 300 people is wholly irrelevant at this point, because that only affects the 300.
Well, it affects the 300 and all of those who are present and will know about the order who weren't formally served. But that's.
What does serving the order on 300 people have to do with anyone else?
My lord, people protest here together. People know what has been ordered by the court, hence the
It would be
compliance.
300 plus anyone who's learned of the order
My lord, yes.
from any.
The 300 and their friends and relations.
Yeah, as it were.
And their fellow protesters on a particular day, yes. But I can't put it any differently, and the difficulty that we have is that the way in which we describe the defendants was,
I think it was at this sort of point where I used to say, perhaps my learned junior will take over.
that'll be later, my lord.
That sounds right.
My lord, can I then go briefly to the service of the claim form on PETA? And I make this purely to save the proceedings, in effect.
Well, what's the, can I just ask, what's the point of that?
Well, my lord, if the claim remains on foot,
Yeah.
then we don't have to start again. And of course, at the moment we have our.
But the injunction will still go, won't it?
Well, I mean,
If you only succeeded
well,
on the
well,
PETA
what we've said in our supplemental note is that depending on the court's determination of the appeal, and if there is a claim that remains on foot that gets remitted back on any basis, depending on what the court says in its judgment, we would be seeking to maintain some form of interim relief.
Yeah, but how can the claim remain on foot when you're not claiming an injunction against PETA anymore?
We weren't claiming summary judgment against PETA.
Well, but the reality, if I can press you on that, the reason you're not claiming, so you're not, why should you be allowed to proceedings to be kept on foot with the purpose of an interim injunction where you're no longer claiming a final injunction against the same person? How can that be right?
Well, Lord.
Anyway, that's your submission.
My lord, yes, it's a different point, respectfully. I mean, I can see entirely that even if the claim remains on foot against PETA, the court may say, well, there's no injunctive relief. But, yeah. And I think the point we make, and I to deal with briefly, is that the judge held there had been effective service. I'll just give my lords the note. It's paragraph 138 of the judgment. And I simply say that no issue had been raised at any time with us about service to claim form on PETA, either by PETA or by the judge himself. And it was simply, and when he'd asked for submissions, it was in relation to service on the first defendant. And then in the judgment, he refers to it being effectively served, but not valid.
Well, what he's saying, he says in the sense that there is evidence the contents of the claim form came to their attention.
Yes.
Clearly right.
So which paragraph would it be?
This is 138.
138, like page 191. 119.
So, but what is, if you actually apply to be joined to proceedings and you are joined, you necessarily submit to the jurisdiction of the court.
Yes.
Is it then necessary to serve the claim form on them in order to be able to proceed against them?
Well,
I mean, normally it's service which subjects the person
Yes.
served to the jurisdiction of the court, but PETA actually, at its own request, was joined.
yes.
It looks as though in that last sentence, in any event, he's saying, well, I'm not really troubled therefore about service on PETA. He's saying, well, technically, I think what he's saying is technically there was no order for alternative service of the particulars of claim on PETA. So technically, they were not properly served, but in fact they have in fact received the claim form, and in any event they've been joined. I mean, I don't think this is a real issue to myself, speaking for myself.
Well, save my lord, that paragraph 167 of the judgment on page 126. And it's the second sentence. There are fundamental issues the claimant needs to address around the validity of the claim form and its service on any defendant. Presently, no defendant has been validly served.
No.
So we're 167. No defendant has been valid. Well, all right.
But that's dealing with the interim injunction, which goes back to the question the Master of the Rolls put to you: how can the proceedings remain on foot if there's no basis for a final injunction against PETA, given the time that's elapsed? I mean, we're talking about 2.5 years now. If there's no basis for a final injunction, then whatever the technical basis of the claim form or what have you, leaving all that to one side, how could there be continued proceedings?
Well, it's a different question whether we were maintaining final relief. I simply don't know.
Well, you said that you weren't.
We weren't maintaining
that you
summary
were,
judgment.
and then that was abandoned post.
Yeah, the maintenance of the claim for summary judgment was abandoned.
Yes.
I don't know if a claim was maintained against PETA at final, to be at trial, but not by summary judgment.
I'm not sure you've shown us where the point about PETA is made. This, I think, was in the February submission.
My lord, that's right.
It might just be.
Yes, it's in the supplemental bundle. That's page 341, paragraph 124.
341, paragraph.
124, my lord.
Oh, thank you.
So the concession is not seeking summary judgment. There's nothing here about.
Yeah, but this is doesn't. I mean, I understand you're doing your best here, but really, it doesn't make you. One of the points you make in the grounds of appeal is you do want summary judgment. You just don't want this content. It needs to be remitted. I mean, you want the matter to be remitted.
For seeking summary judgment against the first defendant.
Yes, but I mean, there's no evidence against PETA. So the suggestion you're making now is that you might want to hold out getting an order against PETA, but not by way of summary judgment. It simply doesn't make sense. I'm sorry to be blunt about it. I know you're doing your best.
I'm correct. My Lord has my submissions. I
I
can't
do.
take any further.
Thank you very much.
Well, that's ground one. Now move then to ground two. And this concerns what the judge said about the substitute draft order. Perhaps I could take my Lord straight to what he said about that. And it's paragraphs 147 to 149 of his judgment. Page 122.
One, two, two. We're now on to ground two.
My Lord, yes. 147 records the submissions following judgment, following hearing, and concerns can be addressed and sets out the definition. And then 148, my judgment, although this may address the point of demonstration in Penzance, it does not define the class of persons unknown by their wrongdoing. A form of wording that defined persons unknown by reference to their presence without consent in the store would isolate people who are arguably guilty of trespass, but defining the group on the basis of an individual's involvement in any of the acts prohibited by the terms of the order is not acceptable. The fundamental problem with the terms of the order is they include prohibitions on acts that are not unlawful per se, and going on unavoidable consequence of utilising this being of suing persons unknown without making any attempt to discriminate between them. And just before we go any further, I mean, we make a few points about that paragraph, paragraph 148. I mean, the judge said it addressed the point of demonstration in Penzance, but it went further than that because it addressed the point of those who were present at the protest and were not doing anything prohibited by the terms of the draft order. So it, even on the judge's analysis, it excluded a large category of what he would describe as the innocent protester.
So, sorry, it required presence of the act, the premises, or in the vicinity, or whatever.
Present vicinity,
Yeah.
the act of protest,
Sorry,
the act of protest against.
let me just see.
Well,
Sorry,
see-
where do I find the reformulation again?
It's in 147, my lord. It's the paragraph.
sorry,
My
yes.
lord, yes. So
Who,
once these,
oh, I see.
firstly, present act, so
Oh,
that gets rid of Penzance,
yes.
then protesting against, and then are involved in any of the acts prohibited by the terms of the order.
Right. Yes.
And although the judge didn't identify which particular provisions of the order he had concerns with, we've already discussed which ones they likely were. And for our purposes, the reason we are here, and the reason why we sought injunctive relief to start with, is our concerns about the exclusion zones, in effect. Those are the principal concerns that we have. Because if my lords have seen the evidence of what happened outside the store before the injunctions, they show hundreds of people outside, an inability to get inside, a funnel and the like, and hundreds of police officers. So that's our concern under this ground. And we submit that the judge was wrong in concluding that a description of defendant can't include prohibitions on acts which are not in and of themselves unlawful. And
So
that,
you can have an order against a defendant who does not commit an unlawful act.
well,
And that's his point here. Really. So what he says is that the defendants must define a class of person by their wrongdoing.
yes.
And you say that's wrong. It doesn't need to define by reference to their wrongdoing.
What I say is that where one, clearly the terms of an injunction must be limited to what is necessary for the protection of the claimant's legitimate interests. And ordinarily, I accept that will be reflected in prohibition on the particular wrongdoing in question. But where one has, as here, what we say is unlawful obstruction of the highway,
by some people.
but by some people, yes, and also unlawful obstruction of my client's ability to get in and out of his premises and of his customers, by some people, of course.
Then you can get an order against all the world
Well,
if it's necessary to protect against those.
my lord, that's right. And I accept that, and one has to be very, I accept,
Even if what someone does is entirely lawful, like my example of someone standing with a placard.
yeah, because,
say,
it's because, yes, we accept that what the court has to try and do is, well, what would be the form of order? I mean, for example, simply to say, do not obstruct the highway, would be incredibly difficult to enforce against an individual. But what we have here, or had before the orders were made, were hundreds of people combining together to obstruct the highway in contravention, we say, of my client's rights. Now, either the court has no power to grant any injunctive relief in those circumstances to protect those rights, or it has to do the best that it can. And for this case, it could look at the size of the pavement, its width, its dimensions. It knows the footfall from the evidence there is. It has the evidence from November, December showing how many people were there. And it has to determine, well, what relief can be granted which protects the claimant's rights, but goes no further than that, unduly to interfere with the defendant's rights. And that enables it, we say, to order some form of exclusion zone or limitation of numbers, which is, is a matter for the court to decide upon what is appropriate. It's not easy. We accept that readily.
We know that the local authority has a power to do that, because that was the Ealing abortion clinic case, where that was challenged. Ealing did that. It provided a zone, an exclusion zone.
Under that act, yes.
Outside the
Yeah.
clinic. It was quite a big exclusion.
It was 100 metres, yes.
So the local authority has that power to do that.
Yeah.
As long as they nobody has. The question is whether the court can do such a thing.
Yes, yes. And, my lord, what we submit is that this does give rise to the consideration of Lord Justice Longbaw's tentative requirements in INEOS, in particular the fourth requirement. And as my lord, that was the term. The terms.
Are you going to take it now? Is this a point where you take it to the authorities?
My lord, yes. I was going to take you first to Hubbard and Pitt and Burris and then INEOS, but I'm happy to go to INEOS first if you like.
No, you can take it in the order you want.
My lord, there were two cases not cited in INEOS from this court, where on applications for interim injunctive relief against named defendants, the court did grant relief, or rather upheld relief, that extended beyond the provision of an established tort. The first is Hubbard and Pitt, and it's tab 23 of the authorities bundle. And this concerned
This is which one?
23, my lord, and it's Hubbard and Pitt.
So it's in the second volume.
I'm terribly sorry, I didn't realise, yes. We had 4 authorities.
Oh, yes. Thank you.
And this was a case where interim injunctive relief was granted by Mr. Justice Forbes against defendants who were named defendants, who were picketing outside an estate agent in Islington. And the appeal, the Court of Appeal, was dismissed with Lord Denning Master-Rolls dissenting. And we get the facts from the head note at 143. And defence were a group of people who deprecated change in the character of the locality where they lived. They organised a campaign to preserve the social composition of the area and to require estate agents to adopt a particularised code of conduct. And they did that by small groups of people who displayed placards with slogans and derogatory of the firms and distributed leaflets and the like.
Is this where is this the case in which Lord Denning dealt with that the common law offence is now harassment?
Well, I don't think he did, my lord.
There was one where, anyway.
He certainly doubted whether watching and besetting.
It was besetting. The
Yeah,
besetting.
he certainly.
This is where he dealt with the besetting.
My lord, that's right. Yes. So interim relief was granted, and in terms of what that relief prevented, it in effect it prevented.
Where are you reading that? Or you're not, sorry.
I wasn't. I'm
No, no, sorry. So we saw, yes, I see.
Yeah, so Mr. Justice
The facts and the head note. Yes,
So
I
he
see.
granted relief. And in terms of what it prevented, if my lord goes to page 160, F to G, which is within the judgment of Mr. Justice Forbes at first instance, it says, if an injunction was granted, they would have to suspend operations outside the plaintiff's offices, but they would still be free at some other
Sorry,
place.
whereabouts on 160?
Just below F, my lord, starting at if an injunction.
Oh, yes, yes. Sorry.
And that's confirmed by the submissions for the appellant in the Court of Appeal. And we have that at page 165 at G. If they are kept out of their rights at the one place where it's most appropriate and effective to exercise those rights by the grant of injunction. So that's what the injunction prevented.
I'm on 165.
Yes, 165, just at G, my lord. That's just recording the submission for the appellants. The first judgment, the judgment for the majority, the main one, was given by Lord Justice Stamp. And this one goes to 179 at H. Lord Justice Stamp sets out the alleged wrongful conduct referred to in the statement of claim. And just below H says, now if I correctly understand that pleading, the pleader is alleging the defendants were committing the common tort of nuisance. That will have to be decided at trial. And in terms of the...
Because they say the nuisance was this old tort
That's right, it's the watching and besetting.
of watching and besetting, and Lord Denning, basing himself on a Times Law report of an earlier case, said he didn't believe it still existed.
That's
That was the issue.
My lord, that's right, that's right. And I think the points made by Lord Justice Stamp and Lord Justice Orr is that, well, yeah, that's a matter for trial.
Yeah, all you have to show now is an argument.
Absolutely, that's right. And at page 187,
Watching and besetting.
at 187 at C, just above C, Lord Justice Stamp addressed the argument of Mr. Turner Samuels that the existing injunction was such a form as would on one... Sorry,
C, yes.
187C, I'll slow down, I'm terribly sorry. He submitted that the existing injunction was in such a form as would, on one view of the law, preclude the defendants from carrying on activities which they are entitled to carry on, and that it ought to be limited so as to allow the latter activities. Besetting the plaintiff's premises so that argument rang did not necessarily involve the tort of nuisance, and he would have the injunction so limited as to prevent only activities carried out for the purpose of compelling the plaintiffs to act or refrain from acting in the way specified. But an injunction so limited would, as a practical matter, afford no protection to the plaintiffs. Indeed, it is, as I understand it, part of the case of some of the defendants that their purpose has never been to injure the plaintiffs in the way alleged, and if the defendants continue to act in precisely the way in which they have been acting, and the injunction had been limited in the way suggested, the very issue in the action would have to be resolved on any motion brought by the plaintiffs for the purpose of enforcement of the injunction. Nothing could be less satisfactory. If the plaintiffs are to be protected, it is the acts of which they complain that must be restrained, the purpose of which they have been done in the past can only be determined at the trial.
And this is clearly in the context of what would then be called an interlocutory injunction.
It was indeed, my lord. Yes, it was.
I mean, it's because you can't really at an interlocutory stage start enjoining people's purposes or acts for particular purposes. It just gets far too complicated.
My lord, I accept that. I accept that. And in the later case, we see of Burris and Azjan, the point again is made, this is interlocutory.
Yeah.
Doesn't necessarily mean you get that final.
We're here, of course, concerned with the final injunction.
My lord, we're concerned with the final order for queer timber relief,
Yes, yes.
where it's not actually very different to what it was.
Well, I mean, it's, yeah, okay. I mean, this was queer timber too.
It was.
Yes.
So can I just say, that I understand this case, but in its proper context. So, the basis of the application for the injunction was the tort, if it still existed, the tort of watching and besetting. Now, there's authority in the Lyons case, which is
Yes.
referred to, which was a union picketing case,
That's right.
which is how this normally arises, where watching and besetting is something which is done in order to persuade people to do something or to dissuade them from doing something
Yes.
which they would otherwise be lawfully entitled to do. It might be to stop working, or it
Yeah.
might be whatever it may be, to
Yeah.
protest and so on. And so there were two issues. There was an issue of law, therefore, before the court in Hubbard and Pitt. The first was, did such a tort still exist? And Lord Denning, dissenting, said he didn't think it did.
That's right.
So that was the end of it for them. The argument before, so far as the other two Lord Justices were concerned, the issue was this: if the tort was, as stated in the Lyons case, that it wasn't simply a matter of standing out somebody's property and watching, as it were, them and harassing them, if I can use that in a non-legal sense, but you had to be doing it for the purpose of dissuading them from
Yes.
doing something they were either entitled to do, or to persuade them to do something they otherwise could refuse to do. And so, what as I understand it, Lord Justice Stamp is saying here is, well, how are we going to know what that is, and therefore how are we effectively going to assist these people, the claimants here, necessarily to be of any effectiveness at all at this interlocutory stage? It has to be simply not to do the acts of whatever their purpose may be. Is that right? That's how the argument proceeded.
My lord, that's right. I think that's right. So it's not this case in terms.
No.
I accept that.
No. I mean, it gets you this far, I suppose, which is, it's not very far, it gets you this far, on the interlocutory injunction, where all they had to do was, there had to be an arguable case what the cause of action was. It doesn't have to be finalised, that it was legitimate to take watching and besetting in its kind of wider context, in order to provide some relief for the claimants.
Well, yes, that's right. Yes, I think the Burris case is a broader principle than Hubbard and Pitt.
Yes.
And then just completing Lord...
This was one of the cases, I think, that was relied upon by Lord Justice Leggett.
In Quadrilla,
in the
that's
late
correct.
case, for saying, therefore, he wasn't totally certain that you couldn't include intention, for example.
Yes.
You couldn't include. That was one of the ones I think he mentioned in this case.
He mentioned Hubbard and Burris, that's correct.
Yes.
Yes.
All right. Anyway, thank you.
And then just below H, Lord Justice Stamp says, as it stands, the injunction is, in my view, no wider than is necessary for the purpose of giving plaintiffs the protection which they ought to have. And Lord Justice Orr agreed. And at 190, just below D, he records Mr. Turner Samuel's submission that it was wrong that interlocutory relief should be granted. The terms of the judgment were so too wide. And he said, I am, for present purposes, prepared to accept it was not unlawful for them to do, namely to assemble outside the plaintiff's premises for the sole purpose of imparting and receiving information. I accept the court must be careful not to impose an injunction in wider terms than are necessary to do justice in a particular case, but I reject the argument that the court is not entitled, when satisfied that justice requires it, to impose a injunction which may for a limited time prevent the defendant from doing that which he would otherwise be at liberty to do. So a slightly wider principle, but I accept, again, in the context of interlocutory relief.
For a limited time.
For a limited time.
I mean, I find that rather... I think the only way at the moment you could justify that statement of principle, the only way, would be to say it may turn out at the end of the day that actually even just doing that might turn out to be unlawful. I mean, you can't see as a matter of principle how you can say, well, it's perfectly true that the only cause of action here is watching and besetting, and that watching and besetting does definitely involve something additional by a particular purpose, but nonetheless I'm prepared to ignore that and say, well, for a limited period of time they can't even if they don't intend that purpose, we'll still prevent it from doing it. I mean, what could possibly be the principal basis for that? You can't stop people for even a limited period of time doing something they're lawfully entitled to do. So it seems to me.
Well, but I think it's reflecting the difficulty there is in determining what people can and can't do.
Well, I mean, yes, if you read this on the basis benignly, you read the judgment of the majority saying, well, we don't quite know exactly what constitutes the cause of action, and that will be determined at the end of the day. I can see the justification for it. But the way he puts, Lord Justice Orr puts it here, respectfully to him, I mean, if he says he accepts that it was not unlawful for them to do, namely assemble simply for the purpose of imparting or receiving information, I don't see how you can restrain even for a limited time.
Yes, and as one sees how Lord Justice Orr goes on, as he gives the example of the non-molestation order, it's very much in the context of, as it were, holding the ring or preventing the damage, pending the hearing to determine actually whether he's been guilty of molesting his wife at all.
I accept that in relation to holding pit. I do accept that. I should take my lords to the to parts of the Master of the Rolls' dissent. If one goes to 172, just below E, he's describing what actually went on. The pickets here consist of a small number of men and women, mostly young. There were sometimes 4 and occasionally up to 8. They stood about the pavement in front of Preble's office. They did about 3 hours on Saturday morning, different persons on different days. Then at 173 at D, the people who stood in front of Preble's offices have behaved in an orderly and peaceful manner throughout.
172D.
173D. He then deals with watching and besetting from 175 at G, and having PETA, the statement principle of the Master of the Rolls and Lyon's Son, says that statement has not stood the test of time. And then 177 below B says the root question in the present case is, were the defendants in this case guilty of common law nuisance? No obstruction, no violence, no intimidation, no molestation, no noise, no smells, nothing except a group of 6 or 7 people standing out placards and leaflets outside the premises, all quite orderly, well behaved. That cannot be said to be common law nuisance. Nuisance of common law. And they said the real cause of action is libel. You'll get an injunction for that. So it does appear that, having discounted the existence of the watching and besetting tort, the Master of the Rolls said, well, on the facts here, there's simply nothing that could arguably be a nuisance, and therefore.
That must be right. I mean, if he was right about the law, that must be right.
Well, that is Hubbard and Pitt. The second authority, which was cited to the judge below, is Burris and Azudani at tab 8. And again, this was interim injunctive relief in proceedings against a named defendant, and the proceedings were brought in a private nuisance, and on an application, I think, made without notice, the district judge, I'm not sure of that, yes, if one looks at 1373, just below C, it was an application, an order made without notice by the district judge, and the prohibition C was coming or remaining within 250 yards of the plaintiff's home address. In due course,
So this is the non-molestation.
That is correct, yes.
No.
Well, in that form, that's right.
Because it's, I mean, the A is assaulting, molesting, harassing, and
Yes,
B
that's right.
communicating. So,
Yes.
yeah.
And the defendant was then committed for breaching the injunction, and his appeal to this court was on grounds that there had been no jurisdiction to grant an injunction in common law proceedings, and that was rejected by this court. And one sees the issue highlighted by Sir Thomas Bingham and Master of the Rolls at page 1374 at D. So that was the issue. At 1376G, Master Rolls records the court's powers under section 38 of the County Court Act. At 1376 at G, and over the page says, this is at a course quite clear, the court cannot properly grant an injunction unless the plaintiff can show at least an arguable cause of action to support the claim, the grant.
So where are we? Just,
It's an A, my lord, at 1377.
oh yes.
But subject to this overriding requirement, section 37 has often been observed as cast in the widest terms. If an injunction may only properly be granted to restrain conduct which is in itself tortious or otherwise unlawful, there would be conclusive objection to term C of the order, since it's plain that Mr. Azadani would commit no tort nor otherwise act unlawfully if, without more, he were to traverse Mandrake Road without any contact or communication with this Burris, exercising his right to use the public highway peacefully in the same way as any other member of the public. I do not, however, think the court's powers are so limited. A moreover injunction granted in the familiar form restrains the defendant from acting in a way which is not in itself tortious or otherwise unlawful. The order is made to try and ensure the procedures of the court are in practice effective to achieve their ends. The court recognises the need to protect the legitimate interests of those who have invoked its jurisdiction. Then cites from Correspondence and Bush, which was an early case on a harassment tort, and then says, just between F and G, it seemed to me to be a valid objection to the making of an exclusion zone order, that the conduct to be restrained is not in itself tortious or otherwise unlawful, if such an order is reasonably regarded as necessary for protection of the plaintiff's legitimate interests. The Master of the Rolls does then sound a note of caution at page 1380, just below F, where it says neither statute nor authority, in my view, precludes the making of an exclusion zone order, but that it does not mean that such orders should be made at all readily or without very good reasons. There are two interests to be reconciled. One is that of the defendant. His liberty must be respected up to the point at which his conduct infringes or threatens to infringe the rights of the plaintiff. No restraint should be placed on him which is not judged to be necessary to protect the rights of the plaintiff, but the plaintiff has an interest which the court must be astute to protect. The rule of law requires that those whose rights are infringed should seek the aid of the court, and respect for the legal process can only suffer if those who need protection fail to get it. That, in part at least, is why disobedience to orders of the court has always earned seared punishment. Respect for the freedom of the aggressor should never lead the court to deny necessary protection to the victim. It goes on, ordinarily, the victim will be adequately protected by an injunction which restrains the tort, which has been or is likely to be committed, whether trespass to the person or to land, interference with goods, harassment, intimidation, as the case may be. But it may be clear on the facts that if the defendant approaches the vicinity of the plaintiff's home, he will succumb to the temptation to enter it, or to abuse or harass the plaintiff, or that he may loiter outside the home, watching or besetting it, in a matter which might be highly stressful and disturbing to a plaintiff. In such a situation, the court may properly judge that it is in the plaintiff's interests, and also, but indirectly the defendant's, a wider measure of restraint is called for. Lord Justice Millett agrees with that judgment, just below G, as does Lord Justice Sheeman, and he again points out there are two interests to be reconciled. That the plaintiff not to be harassed, and that the defendant to be allowed to move freely on the highway. An exclusion zone order interferes with the latter in order to secure the former. On its facts, it forbids what are lawful actions. The defendant has rendered himself liable to such an order because of his previous harassing behaviour. Nonetheless, a judge imposing such an order must be careful not to interfere with the defendant's rights more than is necessary in order to protect the plaintiffs. And the point I made earlier is that Lord Justice Sheeman does draw attention to the fact that the court was there dealing with an interlocutory, not a final injunction, and that it's temporary. And then between A and B, a judge faced with an application for a permanent injunction is faced with a different problem. As presently advised, I consider that any such injunction should include liberty to apply, so the defendant should not be precluded from exercising the normal rights if the fears which gave rise to the imposition of the injunction no longer have any basis.
So that was the case where, taking the words of Lord Justice Sheeman, that was the Lord Justice St Thomas Bingham. This particular defendant did indeed harass and unlawfully was committing torts, harassing, assaulting, threatening, and so on, all that sort of stuff. And so he says, well, the trouble is, if this defendant approaches the vicinity of the plaintiff's home, he will succumb to the temptation to do all these things. And so the easiest thing is, or he may loiter outside it. And so in order to prevent him from committing those acts which are plainly tortious, we should impose the exclusion zone.
Yes.
That's the way it works.
That's
And even though it is possible that he might do things within those exclusion zones, such as walking through it or cycling through it, whatever, would in themselves be perfectly acceptable.
That's right.
And he's not. Yes, that's how it works.
Well, and the reason
How do you apply that to your?
Well, we apply that here. And again, we have to focus on the evidence that was before the injunctive relief being in place.
Yes.
And that does demonstrate on 3 or 4 occasions, 300 or 400 people all making common cause and protesting against the appellants directly outside its store on this small area of pavement, preventing access to and from the store, and also preventing the passage of the public up and down the highway.
Those are all unlawful acts.
My lord,
Assume. I mean, clearly,
my
they
lord,
do seem to be.
yes.
The point is, why does this injunction restrain lawful acts?
But my lord, because
Well, I mean, the Burris case is very much grounded on the particular facts, as my lord has said, that the defendant might well be tempted if he was close to the claimant's house to harass himself.
my lord, because the position here is that in the absence of any order, there is nothing to prevent.
It's not a question of the absence of any order. It's in the absence of an order restraining lawful conduct, as you have to address.
Yeah, but the difficulty comes in, I mean, if one assumes for the sake of argument that what was demonstrated in November, December was unlawful, that is the obstruction of the highway, obstruction of my client's premises. And then one turns to, well, what injunctive relief can the court properly order to seek to prevent that occurring in the future? And
Well, you've got a trial or a summary judgment application,
Yeah.
so you've established that the 400
yes,
strong demo was unlawful.
Yes.
In other words, the Human Rights Act balance
Yep.
tilts
Yep.
in your favour. So that could be said to justify an injunction to restrain a future 400 strong demo. But how does it justify restraining that single person with a placard at 2 a.m. in the morning?
but it doesn't. What it's sought here is to have a term of an order which permits as many people to congregate there and protest as they wish, but which does not amount to an obstruction of the highway or an obstruction of my client's access to their premises. It's trying to fashion with certainty.
So what you have to, the argument here is you're seeking to justify having an order which restrains lawful conduct.
because
we can see from Burris the basis on which that was
Yeah.
justified
Yeah.
on the very particular facts of that case. How do you apply that, as my lord has asked, to this case?
because that form of relief is necessary to ensure that one doesn't have a repetition of the actions in November and December 2017.
Necessary to ensure no repetition
Yes, or in fact, necessary to ensure.
of acts
Yeah.
as seen in November and December.
Or more particularly, necessary to ensure no nuisance to my clients, either by obstruction to the entrance or of the highway causing them special damage.
But why can't you have an injunction in those terms? That obstructing access to your premises.
Well, we do have the obstructing access. That is part of the terms of the order.
That would be unlawful.
But the difficulty comes in terms of, I mean, obstructing the access is one thing, but our access is not simply the entrance there. It is coming out and going either side. We have a right to come and go. And so if you have people, what has happened is you have many people standing either side, creating a funnel, and then, the various things, walk of shame and the like, which,
Well,
in
so
a sense,
you
doesn't...
fashion assuming you can establish that that's unlawful, I can see it could well be. But you're seeking, that hypothesize,
Yeah.
I think you're putting it, that's unlawful. But you're seeking to restrain that which is lawful.
We're seeking the court to determine what is the boundary between lawfulness and unlawfulness. If the court says, well, actually, in this area of the pavement, an unlawful obstruction would not be created by 30 people being present,
Yes.
then the court can so order.
Yes, but you're saying, never mind about that, it is lawful for one person to be there, but we're still entitled to an injunction to restrain.
No, we're only seeking an injunction when the numbers become such.
That's not right. I thought the total exclusions, I'm sorry.
Oh, sorry.
The inner exclusions.
The inner exclusion.
It
Well,
applies to even
Yes,
one
yeah,
person.
the inner exclusion then, that's correct.
Well, that's right. That's a good example.
Yes, well, I think that is for two purposes. Firstly, because of the difficulty of access either side.
I don't follow this. My example of one person with a placard doesn't, in reality, obstruct anyone's access.
Yes. I take that.
Even at 2 o'clock in the afternoon,
Yeah.
let alone 2 o'clock in the morning.
I take that point. But the second point is I think that it was sought because there is evidence of people banging on the windows,
Right, well, you get an injunction stopping people banging on windows.
and I think it was sought to ensure that didn't happen by having an exclusion
What
zone.
we're addressing is the principle
Yes.
as to whether you can have a permanent injunction which restrains lawful conduct.
What we're submitting is that,
You say yes, because it's necessary to protect the claimant's interests.
but no more. So
Necessary.
Yeah,
I mean,
yeah,
that
absolutely,
would be
yeah, that's right,
necessary.
yeah.
Necessary.
and so taking the outer exclusion zone point.
Can we actually, at some point I'd like to go back, I think we need to look or have side by side with these authorities the actual order,
Yes.
because I think it would be useful to go through the different elements. The one in the Burris case was quite simple. It was just an exclusion zone to prevent the man getting near enough to harass the claimant. That's quite a sort of straightforward
Yeah.
thing. Here you've got a whole series of different things. There are exclusion zones, there are particular things that are to be restrained. And for my part, I would like to see how the principle in Burris and Zani would apply to each of those.
Yes. Well, I think that we would only rely upon those principles in relation to the two exclusion zones and the
Just the two exclusion
The
zones. I mean, there are, all right, it's just the two exclusion zones.
and the megaphone example. Well, because I accept that using a megaphone in and of itself is totally lawful.
So you relied for the two exclusions and using the megaphone.
Yes. The other elements we accept can only be to restrain acts which are in and of themselves tortious, and so if there are criticisms of them in terms of their drafting, then that's a matter of their drafting as a...
What is the unlawfulness of the? What is the unlawfulness of any use of the megaphone?
The megaphone, the evidence showed that the megaphone was being used at high volume at all times on siren mode.
Wouldn't that constitute a nuisance?
Yes,
So that's unlawful.
yes, but in determining what is the form of order to restrain that, I mean, if the court was simply to say, do not use a megaphone to cause a nuisance,
No, you can't
that would
do
be about
I accept
uncertainty.
that.
And equally, if it would say, well, do not use a megaphone at a certain decibel level, one has all the difficulties about, well, how does one assess that and from where? One could, I accept, one could say one should not use a megaphone with siren mode on, but you do that and then a different mode is used. And so what was sought here by the order was to try and fashion relief which protected the ability of the protesters to use the megaphone for all their protesting activities, but no more. Well, can I then go to INEOS itself, which is at tab 18 of the authorities bundle. And as my lords know, this was a claim for pure queer timid injunctive relief in relation to anticipated protests at a fracking site. An appeal from Mr. Justice Morgan. And the first ground of appeal was whether or not the judge was right to grant an injunction against persons unknown.
These are final injunctions.
No.
This was interim.
These are all interim.
Interim, yes. And on the issue of the description of here the defendants were described by reference to their future acts. So they're described by the same method that we seek to describe the defendants in our substitute draft order. And Lord Justice Longmore reviewed the authorities on persons unknown in paragraphs 18 onwards, including the judgment of the Supreme Court in Cameron and Hussein.
Just interrupt you for 1 second.
Apologies.
Just going back to the previous discussion. On any footing, if you are successful on grounds 1 and 2, you will want the case to be remitted.
Yes.
I thought you'd said at the outset in order that the evidence can be reconsidered.
Well, I think we'd like it remitted
Yes.
to enable us to determine. Well, I think firstly we would have to amend our description of the defendants.
Yes.
Secondly, we would have to I think we'd have to serve to ensure we have as many people there as possible.
Yes.
And then we would then seek summary judgment again.
You might and at that point then you might have some additional evidence, or there might be other people at that point who might come and might challenge you.
Yes.
We don't know what's going to happen at that
No, we
point.
don't.
So we can't be certain about the state of the evidence at that point.
No. No. Because we recognise there are difficult issues here. The judge did extremely well in seeking to deal with them, unaided by.
He's dealt with them. I mean, the question is whether there's anything the question is whether there's anything wrong, as it were, with what he did that would lead to a remission at all.
My lord, yes, I accept that. But I mean, grounds 2 and 3 also, to an extent, touch upon, even if this appeal fails and this claim fails, nonetheless, my clients have to know what they do for the future. And I accept that the court is not necessarily not in the business of giving advice or things of that nature, but these are cases where.
Well, I mean, but you've got the general proposition from that case, which is binding on us,
Yes.
that you can have an injunction in certain circumstances which restrains lawful activity if that is necessary to prevent a tortious act.
Yes.
And that is binding on us.
Yes.
Well, we'll wait and see what Ms Wilkinson says about that. That at the moment is your proposition. And provided that the injunction is drawn in as narrow terms as possible and is necessary in order to protect the claimant, bearing in mind also that was an interlocutory injunction, so all those factors.
Well, that was interlocutory. It was named parties as well.
Named parties.
and also in this case we're dealing with Articles 10 and 11. And so there need to be a structured proportionality assessment of any of the terms of relief. I accept all of that.
Thank you.
Right.
Sorry, I interrupted you.
My Lord, so in INEOS, Lord Justice Longmore was considering firstly the use of this jurisdiction against persons unknown. As I say, the defence was described by reference to their future acts. And at paragraph 28, Ms Harrison for the Appellants had submitted that the categories given by Lord Sumption in Cameron were exclusive categories of unnamed or unknown defendants. And the defendants, as described in the present case, did not fall within the first category, since they are not described in a way which makes it possible to locate or communicate them, let alone know whether the same as the person
Where
described.
are you reading from?
Paragraph 28, my Lord. This is a submission for the appellant that it would be wrong to describe defendants by reference to future acts. And at paragraph 29, that submission is rejected as being too absolutist. Too absolute to say the claim can never sue persons unknown unless they are identifiable at the time the claim form is issued. And then gives consideration to what Lord Sumption said in Cameron. And midway down in paragraph 29, the sentence commencing "but" on the right hand side.
Yes.
But he was not considering persons who do not exist at all and will only come into existence in the future. I do not consider that he was intending to say anything adverse about suing such persons. On the contrary, he referred to one context of the invocation of the jurisdiction to sue unknown persons as being trespass and other torts committed by protesters and demonstrators, and observed that in some of these cases, procedures were allowed in support of an application for created injunctive relief where the defendant could not be identified only as those in persons who might in future commit the relevant act. And it does appear here that Lord Justice Longmore was identifying a possible third category of unknown defendant. And then paragraph 30, having referred to Lord Sumption, says, this amounts at least to express approval of Bloomsbury and no express disapproval of Hampshire Waste. I would therefore hold there is no conceptual or legal prohibition on suing persons unknown who are not currently in existence but will come into existence when they commit the prohibited tort. He then goes on to refer to the court being inherently cautious about granting injunctions against unknown
Will then
persons.
fall within category with the first category, will they? When they come into existence,
Yes,
they'll then fall within which category?
they would then be the first category. And then paragraph 32, not easy to formulate the broad principles on which an injunction against unknown persons could properly be framed. And then tentatively frames them in paragraph 34. I won't repeat the 6 ways of so doing it. Say, no, the 2 is, it's impossible to name the persons who are likely to commit the tort unless restrained. And 4 is, the terms of the injunction must correspond to threatened tort and not be so wide that they prohibit lawful conduct. And I should also draw my Lord's attention to paragraph 42, where having held that terms of some of the orders were too wide and too uncertain to be properly the ambit of a queer timid relief, recalls the submission of the claimants, the court should grant advance relief of this kind in appropriate cases in order to save time and much energy later devoted to legal proceedings about events that happened.
So where are you reading from that?
Paragraph 42, my Lord. But it's only when events have happened, which can in retrospect be seen to have been illegal, that, in my view, wide-ranging injunctions of the kind granted against the third and fifth defendants should be granted. The citizen's right of protest is not to be diminished by advance fear of committal, except in the clearest of cases, of which trespass is perhaps the best example. And that is then returned to in quadrilla, which I'll take my Lords to now.
So just pausing here. I'm just trying to think ahead. If we decide against you on against your grounds 1 and 2, and you start again, well do. Where we'll be at that point is you will have an order for substituted service, perhaps. You'll have to serve a claim form and the statement of claim on whoever it is you wish to join to the proceedings. And they become joined to the proceedings at the moment that they are commit a breach of whatever interlocutory injunction there is.
On the basis of the gamble principle.
I'm talking about, so these are identifiable people who are going out and you say you give them whatever it may be. Anyway, there is a service, there are identifiable people. So at that point, the identifiable people may or may not challenge the order or say what they've done is lawful or unlawful. So you'll then have a contest at that point. What I'm thinking about is you might then be in, and I'm not saying this is the case, but I suppose you might then be in a stronger position for arguing for an exclusion zone for other people on the basis that there are these people who do this and there are other people who do the same thing. We can't identify them. But it looks as though if they're within this area, there may be this problem. It just seems to me, I'd have to think it through, but it may be that the arguments are rather different when you've actually got named people who can say have done this, this and this.
Well, not really in this case, because the mass protests were before the court granted relief, and then in the first few hours of the first order. Thereafter, there has pretty much been compliance. So those individuals who thereafter have been served with the order and have committed a breach of it tends to be sort of someone who threatens someone, someone who's trespassed into the store. There hasn't been the same level of numerous people that we can identify who have all been protesting together in the inner exclusion zone or the outer exclusion zone. So we are really still reliant upon what happened before the relief was granted and what we say is likely to happen if there is no such relief.
Thank you very much. 2:05.